Shale, I will now take you through when Afca may exclude a complaint. First place to start is Afca rules. Afca rules sets out the jurisdiction and powers of what Afca can do. And I will now provide you with a brief overview of Afca rules that might be relevant. But before I do that, I want to highlight the differences between the matters of jurisdiction and matters of merit. We have a lot of the members come to us and say, this matter must be excluded because I don't think we've done anything wrong. The difference of the matters of jurisdiction and merits are that jurisdiction means Afca can consider the complaint. We have the power to look at the complaint. Matters of merits means we will continue investigating to find out whether that particular financial firm should be liable for the issues complained about, and if so, what compensation should be paid. And just because we find a complaint to be within jurisdiction, it's not an indication where the final findings of the merits will land. And now on to the specific sections of the rules that you might like to have a look. First section is sections A and B. It sets out the eligibility criteria for the complainants. It must be brought by an eligible person, which can include small businesses, corporate trustees, and against a financial member must be a member of Afca at the time of the lodgement. And then section C.1 sets out our mandatory exclusions, includes monetary limits and time limits. But it's also important to note, although the complaint might be outside time, for example, the parties can consent for the Afca to continue to look at the complaint. Third category is discretionary exclusion. Cheryl just mentioned wholesale, in particular sophisticated and professional investors. They fall under our discretionary exclusion powers. And fourth category is a little bit different to the above three, is are declined to consider complaint further. So it is complaint that's otherwise within Afca's jurisdiction, but we may decline to consider a complaint for the reasons set out in our rules. So what about the processes? In terms of the processes, where there is a jurisdiction dispute received, we will issue a view by a staff member. And if we think the complaint is outside our jurisdiction, we'll issue an OTR assessment. And like many processes within Afca, the parties have an opportunity to object. So if the complaint is outside jurisdiction, the complainant may lodge an objection to that jurisdiction assessment. We'll have a look at the objections received. If there's any substance to that objection, the complaint will be now transferred to a second delegate, another senior Afca staff member, or sometimes an Afca decision maker to make a further assessment of our jurisdiction. Similar process applies when a financial firm disputes and disagrees with our assessment as well. Now I'd like to point out a particular eligibility criteria that is relevant and bespoke to investment advice, and it relates to SMSFs. Afca commonly receives complaints about SMSF, stands for self-managed super funds. In particular, complaints about individuals who have received advice to establish an SMSF, roll over or contribute funds to an SMSF, or wind up an SMSF. SMS trustees who have received advice about the management and investment decisions for the SMSF, and also SMSFs who receive credit recommendation and excess lending products and takes out insurance covers. An Afca can consider complaints arising from or relating to financial services provided to the complainant. So it is therefore important to establish who is it actually that received advice. And if it is the trustee for the SMSF that's received the financial services, the current trustee, whether it be individual or corporate trustee, is the correct complainant for that complaint. And I must note here though, sometimes it's not straightforward on the information received at the lodgement to tell who has actually indeed received advice. And it's not until clear later in the process we find out, no, it was actually the corporate trustee or the individual which has received advice. The consequences of that is there's a significant impact on winding up an SMSF if we find that it was the trustee of the SMSF that received financial services. And the implication for the members is that if you have a client that has an SMSF considering winding up, but has an outstanding Afca complaint, we highly recommend you seek independent legal advice, and the complainants or your clients get financial and tax and legal advice, because it carries significant consequences for tax, financial and legal. And now I'd like to briefly touch on A8.3. As mentioned earlier, it's a discretionary power for us to not to proceed with a complaint, which would otherwise be within our jurisdiction. The circumstances in which we would use A8.3s are the complaint is without merit, the complainant has suffered no loss or has already been adequately compensated for such loss and Afca would not award any further amount, or the financial firm has committed no error. It's important to note though, we'll only decline to consider a complaint in this manner where there are compelling reasons. We'll make sure that there is enough information about the facts of a complaint and the issues involved before making a decision to decline to consider a complaint further. And similar to a jurisdictional assessment process, the parties are given an opportunity to object. You can say that A8.3 issued last year, 30% of them were objected to, and if we consider that objection has some substance, we will continue with the investigation and issue a preliminary review or recommendation. I've got some statistics there for you. The numbers may seem small. Last year, out of all the complaints were closed, 64 complaints were closed as an issue or as a result of issue of A8.3. But also I'd like to highlight that those figures are actually about 300% increase from the year before. And it represents only 2.5 of the closed complaints, but again, quite a significant uplift of our use of A8.3 in our space. We'll continue to look to exercise a discretion under A8.3 where we consider it appropriate, the most efficient and a fair way forward. And if you've got any further questions or inquiries, we already have quite a bit of information available on our website. And of course, if you had any further questions that are not answered by any of these, you're more than welcome to contact myself or Shale. I'm going to hand off to Shale for some case studies.
That was a very good and comprehensive explanation of that process. So if you have any questions, we're more than happy to take it. It is an evolving type of process as well. So we're also very happy to take feedback on it and any experiences you've had about it.
Eunice, to the Afca process, and it would be helpful to maybe walk our members through the Afca process and the questions, the pertinent questions, if you could address these as part of that process would be ideal. And that is, in the registration and referral stage, is there a rule that allows financial firms to request Afca to place the complaint on hold pending IDR resolution first? So obviously that's the early interaction with Afca and the members' options to do that, or Afca's process to enable that. The second one, as you work through the complaint process, when can a member raise jurisdictional dispute? At what stages of the process? And to give you the trifecta here is to get all full marks is case managers. How do they determine the priority of a complaint? And there's obviously a few factors here around any financial hardship or concern and how Afca might deal with that, but also this nuance between a standard and complex complaint as well. So yeah, no feet. Over to you. Good luck.
Thank you, Rob. I'll try and answer them one by one. Sure. As I understand it, if the complaint comes to the Afca but hasn't been through an RDR process, we'll send the complaint back to the financial firm to resolve and go through the RDR processes first before we progress the complaint. So there is a definitely time period for the financial firms to have a look at the complaint and see if you can resolve it. In terms of when the financial firm can raise jurisdictional objection, we encourage the parties to come, or the members to raise any jurisdictional objection at earliest opportunity possible, but it can happen anywhere from regional referral to the decision. I mean, ideally, we would like to see any concerns you have about jurisdiction raised earliest opportunity possible, and we'd like to see written submissions submitted, setting out reasons why, and referring to the relevant parts of the rule you think is relevant for our consideration, and also provide all the relevant supporting documents. It's great to have submissions, but we're an evidence-based organisation. We'd like to look at the supporting documents to ensure the evidence and information we have supports the decision we make about the decision, jurisdictional assessment. But obviously, sometimes the matters are complex. It's not until later in the investigation we find or the jurisdictional assessment or objections are raised, and it can happen, assessments can happen at any stage of the process.